Michael Atkins stands before the judge, pleading guilty to operating with cocaine and fentanyl in his system. He admits everything: the accident, the blackout, and the relapse that nearly cost his life.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Atkins. State your name for the record, please, sir.
Michael Atkins.
All right. I have before me a plea form. Is that what we're doing?
Yes.
The plea form indicates that the defendant will be pleading as charged to the offense of operating with the presence of a controlled substance. I think that's second offense.
That is your honor.
Second offense, the 1 year. Upon a successful plea to that charge, nothing. He's just going to plead.
Just pleading, yes.
All right. That's the court's full understanding. Is that correct, counsel?
Yes, your honor.
All right. Let's have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Michael Atkins.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating with the presence of a controlled substance, second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
The courtroom listens as Michael reveals he lost control of his car after going unconscious. The blood test confirmed cocaine and fentanyl, and he doesn't deny a single detail.
Pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
May 25th, 2024, at the location of Oak Valley Drive near Sile Church in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, Your Honor.
Was it cocaine?
Yes, Your Honor.
All right. And you knew at the time that you ingested it, you knew it was cocaine?
Yes, Your Honor.
All right. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
Michael's lawyer explains his relapse, how he immediately checked into inpatient treatment, attends AA meetings, and has a sponsor supporting his sobriety journey.
Had you also taken fentanyl?
Yes, Your Honor.
All right. And at some point you went unconscious and there was an accident.
Yes, Your Honor.
And were you transported to the hospital?
Yes, Your Honor.
All right. There was a blood draw,
Yes, Your Honor.
and the blood draw indicated the presence of cocaine and fentanyl.
Yes, Your Honor.
All right. You don't have any reason to dispute those test results, do you?
No, Your Honor.
All right. And had you previously been convicted of operating while intoxicated on or about February 21st, 2019 in the 14B District Court?
Yes, Your Honor.
All right. Sir, if I accept your plea, if between the time of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, first of all, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
People are satisfied. Satisfied, Judge.
Court will accept the defendant's plea of guilty to this charge.
His mother drove from Saginaw to stand beside him. His sober brother supports him at home. The judge listens as Michael's family hopes for one more chance at rebuilding his life.
Screening and assessment, and is also referred to the Victims Impact Panel. Sentencing in this matter will be December 22nd, 2025, 9 a.m.
Your Honor, I'd like to adjust bond, please.
You may.
So Mr. Atkins is in custody because he admitted to a bond violation for consuming alcohol at his last pretrial. I believe that was 2 weeks. So 2 weeks ago, so he has 14 days credit as of today. He is asking that the court reinstate his personal bond. He obviously has taken responsibility for this incident and that bond violation. This incident is over a year old, I believe. He did go to Oakdale immediately after this relapse, as we indicated to the court last time. He had previously been sober. This was a relapse, and knew what he needed to do, which was go back to an inpatient program. Since then, he does go to AA multiple times a week. He does have a sponsor. So if the court is thinking, if he's released, how is he going to not go back to relapsing? He's been leaning on those supports. He also lives with his brother, who is sober and working his own sobriety journey, as well as his mother, who I believe may be here. She is here. She drove from Saginaw to be here to support him. I hope I'm not speaking out of turn, but she's also gone through her own sobriety journey. So he has a lot of people around him that will support his sobriety. He does have a very good job at a pizza parlor. He wants to get back to that work. He pays child support, so wants to support his children, and he recently got a order for visitation. So there's now an order for.
Michael wants to return to work, pay child support, and follow his new visitation order. His attorney says he's ready for strict bond conditions, even scram monitoring.
He doesn't drive. He doesn't have a working vehicle at this time. And obviously the court knows his license is going to be revoked as part of this case. And obviously Ms. Pilara will be supervising him and with any other programming pieces that will support his sobriety. So given all that, we're asking for the court to consider releasing him. He is, he wanted the court to remember, he did voluntarily come to court. I did tell him he was going to be remanded last time. He is a trustee in the jail already, even during his short stint. So, well, short, not short to you, but so yeah, given all that, we're asking for a reinstatement of his personal bond.
All right. I don't need anything from the people. I'm not necessarily opposed to it if the proper things are in place, but I'm not going to do anything until I have an assessment to try to figure out exactly where he is. Once I can see that, then I'll consider alternatives to his incarceration at this point, with the understanding that, we had the hiccup regarding testing, regarding all of that, and I've been working with this defendant, and we get the violation. So
the judge doesn't reject the request, but wants a full assessment first. Michael's future now hangs on one decision: whether the court believes he can stay sober this time.
The people will support her position and just take that if it needs to be done quickly. So the court can do it without having to have it consulted. Whatever Mr. Barr thinks is good, we'll go with.
Okay.
We'll work on getting the assessment done as quickly as possible, Judge.
As quickly as you can. Okay.
Thank you.
Thank you, sir. Ma'am, thank you for driving down to support your son. Court does call the case of the people first.